again. Welcome to Fusion Consulting Group's next webinar. Our webinar today is focusing on M&A and how to sell your business for more. And hopefully we can simplify things for you in terms of the process that you may need to think about well in the future and as you lead up to the sale of your business. I mean, I'm sure that you agree, Tej, selling your business is one of the biggest financial decisions that you might make in your life. And, it's a big decision emotionally as well.
Absolutely right.
Yeah. And I think that, to create the right value at that point of exit, you've got to consider all your options and you've got to be planned. So, I think it's an important process, but hopefully we can share some nuggets of gold in terms of how to simplify the process. FCG, we are a broad professional services organization working with private clients, early stage companies, SMEs. We have a number of offices around the UK and a couple of international offices, and we work all over the United Kingdom. We provide a number of different lines of service. So we provide outsourced accounting services. We provide wealth management and financial advice. We, as Tej has explained, we have a law firm. We also have something called Fusion Tax, and Fusion Tax provides companies and individuals with statutory tax services and also advisory tax services. And we also have a recruitment business focusing on recruiting into the finance, HR and operations functions. And as mentioned before, I run the Fractional advisory service. So that's Fusion Consulting Group, and we're obviously happy to chat to anybody that would like to find out more about those services. So what are we going to talk about today? So here's the agenda. And can I just say that there is a link, a sticky link in the chat area there. And if you do want to book a little bit of time with Tej for a consultation, then please click into that. That would be fantastic. So we're splitting the agenda into two parts today. So first 10 minutes or so, just in terms of how an FD can support your business as you in the lead up and going through an M&A situation, a sale situation. It's all about bringing confidence to you and peace of mind during that process. And then the remaining period we'll be hearing from Tej in terms of how law can support a business going through that process. If you have any questions, then please put them in the chat. I believe that you can either put them in the public chat or in the Q&A chat area only, but we will try and pick up on them at the end of the session. So let's, I guess, Tej, let's get into the meat of things.
Absolutely. So Adam, I think the first question is for you. So it feels like there's a lot to do in the lead up to a sale. Perhaps you can just help simplify things from the financial perspective, and perhaps just explain what are the key steps business owners should take to prepare for a successful sale, and how do valuation, deal structure, and financial modeling influence the outcome?
Oh my gosh, Tej, I'm going to have to unpack that. That's a lot in there. But let's see what we can do and try and keep it simple. So yeah, look, I'm just going to talk about some of the things that it could be a number of years out, or it could be shortly before an M&A situation, a sales situation. But there are a number of things that you, as an MD or an owner or a shareholder, need to think about. And I guess the first thing on the list is you need to make sure you kind of are clear on what you actually own. You need to have a clear list of your company's assets, the equipment that you have, or the products that you have, and also the property, any property that you have as well. And I think having an inventory list in that sense is going to be really helpful when coming into a sale process. And by the way, why is that? How does that? You might ask, how does that relate to an FD? Well, ultimately, an FD can become the linchpin of pulling all this information together and pulling all the data to that. But so what you own is really important. How you make money and really kind of understanding that is really important. Where does your income actually come from? And what are the costs that you have in the business, and how does the money flow through the business? Because any potential buyer is want to understand that, as it relates to the performance of your business today and also the future performance of the business. Clean records. So you've got to organize your paperwork. So whether you're talking about sales, expenses, contracts, it's got to be easy for someone to understand. And again, the services of an FD are crucial here in terms of being able to present that information to either directly to the purchaser or to an agent that's acting on behalf of the purchaser. So what do you owe as well? Along the way, you will have to invest. You have to invest your own money, but you might also have to raise some money to do that. And you may have some debts that are residue debts. And, you need to be aware of those debts, those loans, any unpaid bills. And you kind of need a plan as to how you're going to pay for them in the lead up to the sale or post the sale, which can be wrapped up into a financial plan. Have your agreements ready. So keep these signed copies of leases or vendor contracts, customer agreements and employee paperwork. All of these things need to be tight, ticked and tied and ready to be presented. What's also interesting is sort of having a good picture as to how the business has changed over time. The way that you make money, the way that you sell, and the costs and the variance in costs and your staffing may have shifted somewhat for the number of years that you've been involved in the business. And it's kind of useful to understand the patterns of change, because that may impact the pattern of change in the future performance of the business. And you need to be honest with challenges. I think although you've got to present the business in the right way, you need to be able to be ready to explain any problems the business has had and how you've overcome them and what problems you might need to overcome down the track post a sale. And I think if it's presented in the right way, honestly and pragmatically, that will put some value on the business. Also, to some small businesses, an organizational chart might feel too heavy, but the purchaser does need to understand who is doing what in the daily operations of a business, whether it comes to services, shipping products, systems, or relationships internally within the business. Understanding that dynamic is really key. And I think, planning ahead for questions, think about what a buyer is going to ask you. It is critical. And I think that will help you position the business well. Ted, you asked me about the sort of valuation, less so the deal structure, but more about the valuation. Well, who runs a business? A shareholder owns a business. Someone who runs the business might be a major shareholder or a founder. There might be several founders or several shareholders. But within reason, prior to going into a sale process, you kind of need to get to a point where you agree what's the range of acceptability in terms of the price. Because what you don't want to do is you don't want to get into the detail and negotiation, which is too far away from what range was acceptable in terms of pricing and deal structure. So discussions around that, can be led by a good CFO, a good finance director to help bring that together. Really, really critical. And then you've got to think about, well, what's someone going to, it's all very well kind of sort of saying, look, this is what we want for the business, but actually you've got to benchmark it in the industry. What is someone going to realistically pay? And at an FD and maybe one or two other members of your management team can have some real input in terms of benchmarking in the market, which will help you understand that. An example of that might be we'll look at what similar businesses have been sold for in prior years. That will give you some great comparison. And I think, just a sentiment that's quite important here is, don't base your price only on the hopes or hard work. You've got to focus on what does the business earn and how strong it looks right now and how strong it could look going forward. Framing the story. Yeah, look, I think a CFO, an FD working on your behalf will pull together a proposal, will pull together an investment memorandum, which will also include some financial numbers. And that's the way to present your business. You can keep it simple, you can keep it short, but it has to be presented in the right way. The promise of the business, grounded in reality, grounded in finance. So I think that's hopefully that kind of gives you a little bit of an understanding of those questions, Tej.
Thanks, Adam. So clearly, I think there's a common thread which runs through that great comprehensive answer you just gave, and that's information really is key during that whole process. So once you have identified a buyer, can you just explain a little what role the data room and the negotiation process plays in ensuring that there's a smooth and a successful business sale, which is what everyone hopes for.
Yeah, you will go, yeah, I mean, facts drive insight, and you will need to have a place where all of the information regarding your business, as it stands today, whether it be operational docs, process docs, organization charts, legal docs, etc., the documentation that you will come onto, Tej, in terms of selling a business, the legal documentation, it all has to go into a data room. All documentation needs to be uploaded into a data room and is accurate. And that is a place where either the seller or the purchaser or advisors that are supporting the process can dive into to make sure that they have everything they need. It is critical. And if it is structured properly, and if it is all there and it is all accurate, things will be much, much smoother. And my expectation would be that a good CFO service or a good CFO and good finance director will be able to, run that process and work with all the other parties to bring that information together. And as I said, the data room does need to be, structured easily for good access. It is also a place where you will end up uploading responses to due diligence. So you will go through a due diligence process after headline prices have been agreed, and the DD, the due diligence questions and answers, should be in that place as well. And look, then it comes down to making the deal happen. And I've been through that process in terms of selling my own business. And what I would say is that it's so critical to have someone that's objective, that's sitting in the seat, working for you, and meaning that, it prevents potentially your emotion taking over in terms of driving the process forward. Incredibly helpful. An FD service, an FD will be able to do that and support you in that process. And it's all about alignment of the terms, the pricing, and bringing that connection together between the buyer and the seller. And the reason why I think that it's doubly important to have someone in the seat to do that is because you've got a business to run whilst you're going through the process of selling. So, my nugget of gold here is don't drop the day-to-day business. Don't drop the ball in terms of the day-to-day business whilst you're selling your company. And I suppose my summary is that, the FD, whether it's your full-time employed FD or whether you need to bring in an interim service, a fractional service like ours, the FD becomes the linchpin of everything that's going on.
Very much, Adam, it does.
Yeah, so hopefully that gives you some perspective in terms of some of the, some of the things that a finance director can bring to the table. But Tej, let's think about 3 years out. And my gosh, I mean, that really seems like a long time out to a business owner who's kind of flat out running the business. I mean, why start that early?
Well, preparation is key, is the very short answer, Adam. And a good sale has to be regarded not as an event, and it really is a process. Unfortunately, something that most owners badly underestimate just how long it takes to do the good version. So, what are we looking at? The value of the business often sits in things that, you simply can't fix in a fortnight. So the idea of, looking and preparing, it can be 3 years out, it can be 18 months out. That's a movable target, but at least 18 months out, I'd be saying. And then this gives you the time to fix some critical issues, which if they exist, they're not going to get fixed in a fortnight. What am I talking about? A few examples: a clean cap table. The number of times when I've acted on both the buy and the sell side, and you look at something as simple as the cap table and see, well, actually, it doesn't reconcile with any of the company's own records or the company's house records. That's an easy fix, and that really shouldn't be something that's discovered while the negotiation process gets underway. That really is a basic bit of housekeeping which needs to be taken care of. Likewise with, if you have critical customers or key suppliers, you want to be checking their contracts, checking their terms and conditions, and look for things like a change of control. Because what you don't want is a key customer, a key supplier to the business, and within their contract, they have a change of control provision, something that enables them to terminate the contract once you announce the sale. Now, if that does exist and you identify it early enough, you can then go and have a conversation and perhaps get something like a comfort letter. And if the conversation doesn't go well, you can then at least start planning and strategizing for diversifying your supply base or diversifying your customer base. Again, catch this problem early and not late. I guess the third element also is, look, you're selling the company. The point of selling the company is you no longer want to have an active role in that company. You want to go off and enjoy the fruits of your labor. So what you need to ensure is that you have a management team that actually runs the place without you. That is key as well. So make sure your management is in place, make sure they're incentivized, and related to that, take a look at their employment contracts. Make sure that the restrictive covenants are up to date, because if some of the key employees do decide to leave, you just want to make sure that things like your restrictive covenants, your non-solicitation clauses, that they are current, they are up to date, and they are enforceable. So I guess the key message here is, if you start early, then these, with all the things I've described, they become strengths that a buyer pays for. Leave them to the last minute and they will inevitably become a price chip. Now, in terms of the three basic elements that we're looking at here, you can break it down into three phases. There's three key preparation phases. So you build the foundation first, you get diligence ready second, and then the last part is that you go into deal execution. So again, the point of starting early is simple. You arrive at the deal on your own terms, and you're not scrambling because the buyer's turned up and you're simply not ready.
Yeah, I couldn't agree more in terms of the employee item, in the sense that any purchaser is going to be looking at, well, look, I'm buying your products, I'm buying your service, I'm buying your company. What's left for me once you head off into the distance? I need someone to execute the business from here on in. So yeah, so I guess, well, look, the timeline's changed. 12 to 36 months, build the foundation. You put that down as one of your steps, Tej. So yes. Yeah, what's actually on the list there?
Well, this is the, what you could regard as, and frankly it is, it's the unglamorous structural groundwork. But not all things are glamorous, and you really do have to get this structure, get the foundation solid, because this, frankly, is the first thing that lawyers pull apart. And again, I've been involved with many transactions where I'm acting on the buy side, and some of these elements are the first thing I look at. And if I can get my hands on some issues, on these 5 issues that I'm going to talk about, immediately it becomes a price chip, because that's what I'm doing. If I'm coming in as the buyer's lawyer, I am looking for excuses to win favor with my client. How do I do that? By reducing the price my client pays. So these are the 5 areas that I would say key structural issues to get right from the get-go. And again, give yourself at least 12 months before you're going into deal execution. 5 things. First, corporate housekeeping. I touched on this earlier. Companies' house filings, really boring, but they have to be up to date. Statutory books, make sure they're in order. And make sure you have a share history that reconciles with what we present as the ownership of the shares. Key point to keep in mind is, from a legal perspective, the key document to prove ownership of title of shares in an English limited company is the register of members that the company maintains. There's been a change recently. It's coming into force very soon. The old requirement, the old Companies Act requirement, not for a company to have statutory registers, including a director's register, a register of charges, so on and so forth. A lot of those registers now have fallen away. Companies no longer have to keep those, but one register they have to keep, and it's this. It's the members register. Tied to the members register is the register of transfers. So look, really basic stuff, but the number of deals that I've done where the people running the business think that somebody else is taking care of it, and then perhaps rely on a firm of accountants, bookkeepers, somebody's dropped the ball, and then there's a lot of paperwork that needs to be tidied up. It can be done. These are not insurmountable problems, but let's identify them early. Secondly, shareholders agreement. Check if you have one. Check for terms that you need to deal with. Crucially, if you don't have one, now's the time to consider putting a shareholders agreement in place. Why would you want to do that? good example is if you have one or more minority shareholders in your business. So at the time when you come to sell, if you don't have the provisions in the articles and the model articles, which most companies are incorporated with today, and the old Table A articles, and I'm going to show my age here, going all the way back to the Companies Act 1985, none of those have any provisions, what we would call drag-along provisions. In simple terms, this enables you as a majority shareholder, if you want to sell the company to a third-party purchaser, you can effectively drag along a reluctant minority shareholder and make them join with you in that sale. Now, you can only enforce them to do that if you have a provision to that effect and a shareholders agreement. That's where you find it. So check if you've got one, make sure you adhere to it. If you don't have one, the advice almost always is put one in place. Thirdly, business asset disposal relief. The rules are quite complicated, but in simple terms, you want to check, work with your accountant, work with your tax advisor, and make sure that you qualify for all the reliefs and you meet all the relief elements, all the requirements, and that you flag any risks early. Because fixing shareholder structures, they do take time. Fourthly, it's always good to do an IP audit, because you want to make sure we have a company where a lot of value sits in the company's trademarks, its software, its know-how. You want to make sure the company actually owns these things. As a matter of UK law, where an employee creates intellectual property during the course of employment, that intellectual property belongs to the employer. That's not the case when you don't have an employment contract. And a good example is owner-managed businesses, where you have a founder at the very beginning busy building the company. They're not going to have an employment agreement in place, certainly not at that stage. So all of the IP that's created by the founder in that early stage, that actually belongs to the founder because there is no employment contract. So this is a key. Make sure you've gone back through your history, and to the extent necessary, and in many cases it is necessary, make sure you have a clear assignment of intellectual property rights going to the company. If this is discovered by the buyer during their due diligence, again, that immediately becomes a price chip. It's a simple fix. Identify it and deal with it now. Lastly, property. Property is the obvious one. There are lots of property taxes and reliefs available. There are different structures you can discuss with our colleagues at Fusion Accounting, at Fusion Tax. But it's good to get an idea of how you want to hold your property interest, and whether you want to, if you have a trading company, whether it makes sense to then create what we call a PropCo, a property holding company, rejig your properties around the group, and do that now. Don't do that later. As I said, none of this is frankly difficult on its own. It's definitely not rocket science, but they always take longer than you think. And it's near impossible to fix cleanly once you have a buyer already looking. That discussion, when a buyer discovers a problem, is not, hey, can you fix this before we complete? It's, oh, you've got a problem here. I'm not going to pay you what I said I'm going to pay you. And again, price chip. This is all about price gouging. And this exercise is to ensure, as the title of the webinar says, to ensure that you sell your business for more money.
Absolutely, yeah, that's a really good starting list. 12 to 36 months out. Thank you, Tej. And I will just remind everybody that when my part of our business, the fractional business, and when Tej is working on M&A deals, we work very, very closely with Fusion Tax to provide more detail in terms of the most tax efficient way to go through a sale and how to capitalize upon the proceeds afterwards. So that's good. So yeah, so look, I'm a business owner, and yeah, we're actually making some real progress here, and we're now 6 to 12 months out, Tej, and I'm thinking, oh gosh, kind of I've got my list, and I've got my list from Fusion. It's a simplified list, and but we are 6 to 12 months out, and there's still some stuff to do, right? So we'd start to talk about things like due diligence and diligence readiness. What is your take now, a year or so out?
Well, so this is where, once you've got your foundation, your structure in place, now this is where there needs to be a shift in your mindset, and the shift is from, is it right, to, can a buyer see that it's right? because a buyer is only going to give you credit for what they can see. Now, some of this Adam touched upon earlier, but it is worth repeating. So it's all about getting your documentation, getting your documents, getting your proof and your evidence ready for detailed due diligence by the buyer. There's about 5 main areas here. The first one is cleaning up your financials. You see this very often in owner-managed businesses, where there is a blurring of the line between what are personal expenses and what are company expenses. Everyone does it. It's not intentional. It's just a fact of life. Not a problem with it, but you need to spot it and regularize it. The same goes for related party transactions. The key here is these items, they can impact upon your EBITDA, and you want to make sure that you provide a clean and supportable and verifiable EBITDA. Otherwise, that becomes a valuation issue, which becomes a price issue. So let's do the financial cleanup as a very important item. Secondly, I touched upon this earlier, it's a concentration risk. If you've got a key customer who, say, is responsible for 40% of your revenue, this is something to address now. You don't want to address it later on. It becomes a stick to beat you with, to beat the price down with.
Yeah.
Third point is the management layer. Again, touched upon this earlier. You just want to demonstrate that the business can actually run without you. Clearly, you were instrumental in, and every founder is, in founding the company, shaping the company in the founder's own vision. When you come to the point where the founder is now looking to move on, make sure the management structure is in place, because that's what the buyer will be looking for. You get very few buyers who are going to want to be really hands-on and actually take full day-to-day at the coalface control. That doesn't happen very often. Really, it needs to be a company that they acquire where the value in the EBITDA is going to hold up after you've left. So make sure you've got that strong management layer in place. Key contracts. You want to make sure that you've gone through and you've identified change of control provisions and assignment clauses. Because what you don't want to happen is, and I mentioned this earlier, you have a key supplier. If they've got the right to terminate your contract, have that discussion early, try and get a comfort letter from them. Don't let that be a last-minute surprise. And you don't want your biggest customer, who supports a very large part of your revenue, to suddenly disappear as soon as the deal is announced. And employment contracts. You want to make sure that your key employees, that the contracts are reviewed, in particular restrictive covenants. Now, one issue that we see on the employment law side, and in fact, I'm just about to, next week on my LinkedIn post, this will be a subject of one of my regular guides and articles that I publish. It's on the subject of restrictive covenants. What people don't realize is when you start employing somebody in year one, and you have your restrictive covenants in place, hopefully, as that employee gets promoted in the business and then attains a degree of longevity with the company, 5 years down the line, the restrictive covenants you had agreed 5 years previously may not, and in fact almost certainly will no longer be enforceable, because they do not apply to the seniority of the employee as he then exists. So that's a simple fix, but a very, very easy thing to miss. So you can think, yes, I've got this key employee, he's got a contract signed years ago, the covenants were done by a law firm, nothing to worry about. That is not what you should be thinking. Take the opportunity now to look at those covenants, and to the extent necessary, in a lot of cases, we have employees who've been with the company for a long time, it is actually necessary to refresh some of those contracts and give a bit more force to the restrictive covenants. So, in summary, this is a phase when you're building the evidence file and not just running a good business. Sorry, Adam, I interrupted you.
No, that's all. I was just saying, our slides so far have simplified a lot of the process, but as everybody can see, it does take quite some time to make sure all of these things happen and occur. So, starting early makes a lot of sense. And I think there's a recurring theme here with regards to succession planning and your employees who are going to take the business on into the new environment. So lots of things to focus on. So we've got about 10 minutes left, guys. So hang on before you go and get your lunchtime sandwich. We've got a couple of slides left to share with you. So, okay. Yeah, I mean, the adrenaline's kind of kicking in now. I'm like, I'm running a business and I'm getting a bit excited. We're now potentially only 6 months away from selling. Could be because we've been in that process of taking the business to market, and we have a short list of potential buyers, or there's one particular buyer that's popped up and is hell bent on taking over my business. So the adrenaline pumping now. 3 to 6 months out. What do we have to do to prepare for the execution?
Well, I think this is where things start to get real. And you've done all of the groundwork we've just talked about, and now this is when you start to assemble your team. So you start with, make sure you appoint your advisors early. We're talking about corporate finance, legal, tax, and financial planning, all working together from the start and not bolted on late. Now, this is where, and Adam mentioned this earlier, this is where our group model really does earn its keep, because you're not having your accountant and your tax advisor and your financial planner sitting in different offices with different companies, talking or not talking with each other. We bring it all under one roof, and we have those discussions in-house, and it's not something that we're going to charge you for. So that really is our USP. And by having that approach, we ensure that nothing ever falls between the cracks, because we all constantly talk to each other. Secondly, tax planning. Taxes, I don't need to tell anyone that our tax legislation is far too complicated. There are lots of reliefs. There are lots of traps as well. So you need to make sure you've got really good tax within. We have a fantastic tax planning team here, Fusion Tax, and they'll help you work out issues like the timing of the disposal, looking at how the consideration is structured, whether it makes sense to have an earn out and deferred consideration, and what the tax implications of those are. And also whether the sale itself qualifies as a transfer of a going concern. And that's very important for VAT purposes. And if you get any of this wrong, it is expensive. So get your tax advisor in at the same time as your lawyers, at the same time as your corporate finance advisors.
Thirdly, can I just jump
Sure.
in there? There'll be some sophisticated members of the audience here who may have been through the process once or twice, and there'll also be some people that are probably going to think about going through it for the first time. Can you just define what you mean by consideration? That I think that would be helpful.
Sure. So consideration, we're talking about the money you get for selling your company. That can be structured in a number of different ways. The best way, clearly from a seller's perspective, is that you get all the cash on day upfront in one go. Perfect. That's a nice to have, doesn't always happen. So then you get into structured consideration. So a simple structure would be you get 50% paid now, and then you get 50% paid in year 2. So simple deferred consideration. Another form of that is something called an earnout. So you would get 50% on day 1, then you would get 25% at the end of year 2, 25% at the end of year 3. But those payouts in year 2 and year 3, they are linked to the financial performance of the company. So then you would agree certain performance metrics. In a lot of cases, it is linked to the company's EBITDA. So what you'd say is, provided the company's EBITDA hits this certain value, and that value is going to be keyed off the starting EBITDA value, there'll be a little element for the natural growth that the buyer will want to see in the company. But so long as a company continues to show a strong EBITDA performance going forward, then you'll get your consideration in stages going forward. So those are really the 3 simple variations of the cash consideration. But cash consideration, cash is king. If we can get that, and we'd always do our best to negotiate when we're acting for a seller to get that on day 1.
That's great. And then we've got the data room and also confidential strategy.
Yeah, and this is what you mentioned earlier. Cannot emphasize enough how important it is to build a data room, build it in this phase now. Yeah, again, people are surprised just how much data is actually required, because we are anticipating, when we're acting for the seller, we are anticipating what the buyers are going to request, and the buyers are going to give us a 25-page, if not more, list of, it's called a legal due diligence questionnaire and a document request list. So let's get all of those documents together. Let's put them in a virtual data room. Let's get well organized, well structured, because then when the process starts for due diligence, we can then, acting on your behalf as the seller solicitors, from day one, we start applying pressure on the buyer saying, hey, get on with your task. Let's get your due diligence done and let's move on. What you don't want to be in a situation is where your DD room is the opposite of what I've described. And if you're having to add documents piecemeal and reactively, well, inevitably, this drags out the whole due diligence process. And a DD process that takes too long will inevitably discover issues. The buyer will always discover issues the more time you give them. So well-ordered data room helps you get the deal done quicker. Finally, a confidentiality strategy. So you want to protect the process and you want to make sure that the information and news about the fact you're negotiating for selling the company, that it doesn't leak too early, because what you don't want to do is upset your key employees, is upset your key contracts. So you need to ensure that you have a system in place to make sure there is no leakage. Now, that can sometimes be difficult to do because if you're taking and you're gathering data and you're gathering documents from your company, and if you haven't advised certain senior members of the team, they may, if they're cotton on to you doing all this document gathering, then they're going to start asking questions. So you need to think through that process and how best to gather and do all the required work, but without letting the cat slip out of the bag too early.
Very good. Thank you. Oh my gosh, we're at that point.
We're there now.
We're there. We're at that point. So
we can see the finish line.
Yeah, we can see the finish line. We can see let's call it. It could be called the transaction line, maybe.
There you go. There you go.
Transaction and beyond the actual deal itself. Just briefly, Tej, just as I said, just walk us through what actually happens.
Sure.
Once the buyer's actually at the table.
Okay. Well, this is a very clearly defined process. It doesn't really change from deal to deal. There are several different elements. So you start with the NDA. This is your non-disclosure agreement. This is where the parties agree with each other that we will exchange. Almost always, all the information comes from the seller. That the seller will give the buyer information. The buyer agrees to keep that information confidential. Secondly, the heads of terms. The heads of terms are very important. It's just technically, it's a non-binding agreement. So it's a term sheet. It gives a basic summary of who is buying what and for what price. However, although it's non-binding, the advice is always to get the lawyers involved at that stage, because even though it's non-binding, actually, once you've put certain goalposts in place, those goalposts actually become difficult to shift in your favor once the heads of terms is agreed. So you want to make sure that you get the lawyers involved at that stage and do not be fooled by the non-binding statement on it. By the way, I don't mean to keep advertising my LinkedIn site, but if you go back and visit my site, you'll see I've done a series of articles, and actually one of them recently is exactly on this topic. It's on heads of terms and why you need to get legal advice on them early. Then you have warranties and disclosures. So a share purchase agreement is essentially, at its heart, is a series of promises by the seller to the buyer, promising that the business does and does not do the following, or doesn't have any claims, hasn't had any insurance claims, that the accounts are up to date, that the taxes have been filed. These are what's called warranties. And for the sellers, then acting for the sellers, we then help you disclose relevant information against the warranty. So to give you an example, if a warranty says that there have been no claims against a company in the last 12 months, and actually there was a claim by a customer for £5,000 for a faulty product or service that you delivered, well, to avoid you then being sued after completion, it's quite simple. There's something called a disclosure letter. Disclose it in the letter. It's before the buyer, and then the buyer cannot sue you for that. So it's an exercise. The warranties help the buyers flush out information. Disclosures help the seller to actually explain the risk fully to the buyer, and then the buyer has to go in with their eyes open. Earnouts, we've already talked about. And so part of the price, it depends on future performance, and you want to make sure that you've got sufficient detail about the metric that you're using, almost always EBITDA, and how it's measured and what your protections are to have it nailed down in the draft. And to give you one quick example, for what you in most earnout calculations, you will have something in there which will allow the buyer to make certain investments in the company, but you don't want them to make huge amounts of capital investments in the company, which is going to have an impact on the company going forward and its short-term EBITDA performance. So you would have some restrictions around that. And then lastly, don't forget the period after completion is just as important, because you've now sold your company, you've got a bag full of cash, but remember, there are a bunch of restrictive covenants which you are going to be subject to, and this will all be in the share purchase agreement. And then there's the handover period. And then right at the end, once you've got your bag of cash, you then want to think about, well, what do I do with this now? That's where our friends down the corridor, Fusion Financial, come into their own. So they will help you invest and think about investment of those proceeds for tax and inheritance purposes. Remember, deal closing is a milestone. It's not always the finish line.
So look, I think hopefully everybody's found this a useful session. I mean, we've covered, what an FD can do to support your business, bringing financial confidence and peace of mind to the process. We've also, from a legal perspective and a financial perspective, described the steps that you can take over 12 to 36 months and the time leading up to the transaction. But thank you for your time, everybody. It's been a pleasure for Tej and I to kind of be on a call with you. We are always here. Please do be in touch if you'd like to, and we will certainly make you aware of other webinars that Tej and I will be holding, or other service lines within our business will be holding going forward. So thank you very much for your time.